Today, the Federal District Court in Connecticut ruled against gun owners and the Second Amendment in our lawsuit to overturn Connecticut's semi-auto ban and standard capacity magazine ban. It's an outrageous ruling. It insults law-abiding gun owners. It flies in the face of multiple Supreme Court precedents, and it's one of the worst examples I've seen of crazy judicial gymnastics in order to uphold gun control. And believe it or not, it's not actually a setback for gun rights. But before we get into all those fun details, take a minute, if you would please, to like this video and subscribe to our channel for updates on our lawsuits and on other Second Amendment news. All right, so first off, let's put today's news into perspective with our general overall strategy, right? Because it's easy to hear about an outrageously anti-gun court ruling and get discouraged. But here's why there's reason to be both encouraged and hopeful in spite of today's news. First of all, bluntly speaking, we never really expected a positive ruling at the district court level in Connecticut. It's a very blue state. The judge for our case, Judge Janet Bond-Arterton, is a Clinton appointee. This wasn't a friendly venue for us, but if you want to challenge the Connecticut assault weapons ban in the federal courts, this is where you have to start. You can't appeal it without going through the district court first. Second, and along those lines, the strategy has always been to get a Supreme Court precedent to end these gun bans nationwide. And to that end, we have currently 7 lawsuits challenging semi-auto bans and standard capacity magazine bans all across the country. So once we appeal one of these cases to the Supreme Court and hopefully get a good ruling, that will apply to all the other lawsuits on this issue, including our Connecticut case, if it's not the one that the Supreme Court actually ends up ruling on. Third, these lawsuits have a twofold purpose. Number one, we want to end semi-auto bans nationwide, right? That's the first goal. We want the Connecticut gun ban to be struck from the books. But we also want the courts to be forced to follow last year's Supreme Court ruling in New York State Rifle and Pistol Association versus Bruen. And we want the Supreme Court to enforce it. And if no one is willing to bring the legal challenges and force the lower courts to either comply with the Supreme Court's precedent or to outright defy Bruen, then Bruen is just a piece of paper. Just as an example of what we're talking about, when the Supreme Court issued its landmark pro-gun ruling in D.C. versus Heller in 2008, what followed was over a decade of lower courts outright defying what Heller said and upholding bad gun law after bad gun law, with the exception of the McDonald ruling in 2010. And for the most part, the Supreme Court did nothing. We don't want that to happen again with Bruen. That's why we're bringing lawsuit after lawsuit to force the lower courts to face the issue. Now, we did know all along that a lot of lower courts would resort to crazy legal gymnastics like these in order to avoid upholding the Second Amendment, like this judge has. So that's why we have to bring the issue ultimately back to the Supreme Court quickly, because only the Supreme Court can enforce its own ruling. And we at the National Foundation for Gun Rights are not going to let the Supreme Court get away with ducking the issue for another 10 years. They gave us an outstanding ruling in Bruen, and now it's time for them to enforce it. And with these semi-auto ban lawsuits that we've got, currently 7 across the country, we're working hard to bring them as many opportunities as possible, as quickly as possible, to force the lower courts to actually follow the Constitution. Now, with that said, I do want to hit a couple of the highlights from today's ruling out of Connecticut. Now, when we asked Judge Arterton to block the Connecticut semi-auto ban from enforcement, we pointed out that it's a very simple case. Bruen said that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. Then, if the government wants to ban guns, the burden of proof is on that government to show that the history and tradition of the Second Amendment is consistent with that type of gun regulation. Now, they can't do that because there are no historical analogs for outright bans of commonly owned weapons. Now, that's a very plain, straightforward case. So to get around that, this judge had to follow some pretty crazy logic in some places and then outright contradict the Supreme Court in other places in order to get the results that she wanted. Now, we unfortunately don't have time to go over everything. It's a very long and convoluted ruling, but I did want to hit a few highlights. First, Judge Arterton said, and I quote, Nothing in Bruen or any of the other cases that plaintiffs cite grants them an automatic presumption that their conduct is constitutionally protected, which defendants are then required to affirmatively rebut. That's a flat-out lie, y'all. This is what Bruen said, quote, "In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct." It doesn't get any plainer than that. So here's another one. Judge Arterton said, and I quote, "A weapon must be both possessed for the purpose of and actually used for self-defense in order to fall within the Second Amendment's protection." This is majorly twisting the common use test. The Supreme Court said in Heller that the Second Amendment, quote, "guarantees the individual right to possess and carry weapons in case of confrontation." But according to this judge, if you own it for self-defense, but you're lucky enough to never actually be attacked and have to use it, too bad. The Second Amendment doesn't protect you. Now, obviously, that is not what the Second Amendment says, and that's not what the Supreme Court said either. And then we have my favorite, quote, "Further, to adopt plaintiffs," and that's us, "proposal would mean allowing the analysis to be driven by nebulous subjective intentions, such that if enough individuals filled out a survey stating that they owned high-powered shotguns or niche sniper rifles for the purpose of self-defense, that would satisfy the common use test regardless of how the weapons were actually used, a result that the Supreme Court does not indicate in the slightest that it intended." In other words, we can't possibly take the citizens' word for it. They might not actually have them for self-defense if the majority of them never get into dangerous situations and have to use them. Never mind that most citizens, myself included, own our guns just in case. In other words, this judge basically thinks that we're all liars. This is a massive insult to law-abiding gun owners everywhere. Now, when we asked for the preliminary injunction in this case to block the enforcement of Connecticut's gun ban, our lawyer, Barry Arrington, actually addressed this very point with the judge, and here's what he said in our filings. "Furthermore, courts and legislatures do not have the authority to second-guess the choices made by law-abiding citizens by questioning whether they really need the arms that ordinary citizens have chosen to possess." While Heller noted several reasons that a citizen may prefer a handgun for home defense, the court held that, quote, "whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid," end quote. The court reaffirmed that the traditions of the American people, which include their choice of preferred firearms, demand the court's, quote, "unqualified deference," end quote. All of this simply underscores the fact that gun grabbers, judges, and politicians alike, they don't just despise the Second Amendment. They despise you, the law-abiding gun owners that it protects. And that's why your National Foundation for Gun Rights is fighting for you every day in the courts. And that is why we're taking the fight to the enemy territory in deep blue states like Connecticut. Because the Second Amendment applies everywhere. And as the Supreme Court said, the enshrinement of constitutional rights necessarily takes certain policy choices off the table. And that right there is what we're fighting to enforce. If you'd like to help us, we'd ask you to consider a generous donation to our legal war chest in the link in the description below. And don't forget to like this video and subscribe to our channel to stay tuned for more updates on this litigation.